may, I'll turn now to the Court of Appeal's reasoning, page 207 in the electronic numbering. Judgment of the Master of the Rolls. And I'll just focus on the objective justification analysis that is undertaken. Before I do, just in passing, and in part in answer, I think, to some of the questions raised by my Lord Carnwath, the challenge in relation to principles of equal treatment and fairness is considered by the Court of Appeal at page 214, paragraphs 31 through to 37. And I just, for your notes, highlight paragraph 34, where the Court of Appeal upholds the judge below, saying that the relevant assurances to TMR fell within the scope of the equal treatment principle that the OFT was obliged to apply. And there are two sources there. The first is Crest-Nicholson.
Yes.
Which was a judgment, just for your notes, it's in Authorities Bundle 1, tab 8. And at paragraph 50 in that judgment, page 1027, I'm not going to take the court to it, there's a recognition of the application of equal treatment in the steps leading up to the imposition of a penalty. And that position was not challenged in these proceedings. And furthermore, as you'll see further down in the quoted section in 34, the OFT specifically adopted consistency in the principle of equal treatment being the approach being followed in relation to the ERA. So whether or not it's as a matter of law or as a matter of the statement and indication by the OFT in the course of giving the ERAs, we say that the principle of equal treatment was applied, and as it's described in Crest-Nicholson is that which I articulated earlier, similar cases in a similar way and less justification for doing otherwise. And we say it makes no difference whether or not this was by dint of our statements or by dint of the operation of law in relation to those matters. So, turning on then to the reasoning in relation to the objective justification ground, begins at paragraph 48, page 218. And there's a discussion of the nature of the mistake in paragraphs 48 through to 51, concluding that the Court of Appeal agrees that a mistake was inadvertently made by the OFT at the end of 51. Then in 52 and 53, there's discussion of the Nat West case, to which I briefly took the court, and referenced the fact that the Court of Appeal puts it, that Mr. Justice Collins relied on this decision as authority for the principle that as a general rule a mistake shouldn't be replicated. And then the conflicting submissions are considered in relation to that in paragraph 53. Then over the page, and this may well be why there's been discussion of legitimate expectation and perhaps too much time spent on it, but 54 is where the concepts of legitimate expectation were introduced by the Court of Appeal, where it said that they are of some assistance here. It's well established that legitimate expectation can't be relied on to require a public authority to act in breach of its statutory duty or do something ultra vires. Not suggested it's ultra vires here. But the courts have considered whether a public authority may defeat a legitimate expectation where the expectation has been created by mistake. And the citation of Lord Justice Peter Gibson in Begbie, just for your notes, that case is in the Authorities Bundle, Bundle 3, tab 31, and this passage is actually at page 1860. He said, where the court is satisfied a mistake has been made, this is in the giving of legitimate expectation, the court should be slow to fix the public authority permanently with the consequences of mistake. More importantly, he went on to say that the question of whether authority should be permitted to resile from a mistaken statement depends on whether that would give rise to unfairness amounting to abuse of power. And that, of course, is a phrase that has been treated as synonymous with this notion of conspicuous unfairness, both of which may be somewhat elusive, as my Lord Sumption raised as a question. The law relating to legitimate expectation is grounded in fairness. The question in the present case is whether the OFT should be permitted to resile from a mistake, where to do so results in unfair and unequal treatment of the appellants. And we say here that if you're drawing on the analogy with legitimate expectation and this concept from Begbie, then when you are considering equal treatment, you're asking yourself whether or not a difference in treatment is objectively justified. But we recognise that if you're drawing on an analogy, then that objective justification will be qualified, at least to the extent of not allowing unfairness amounting to an abuse of power. Now, whether or not one sees that as part of the objective justification test or as a three-part test of identifying equal treatment being applicable, whether or not there is a difference in treatment, whether that's objectively justified, and whether in the circumstances it would be so unfair as to amount to an abuse of power to resile from the position or maintain the difference in treatment.
I mean, it's fair to say, I was just looking at the reference to Begbie and what
Yes.
Lord Justice Peter Gibbon said.
Yes.
I mean, what he suggests is there may be unfairness which can be corrected where the person to whom the statement is made, where there's been detrimental reliance
Yes.
on the statement before it's corrected. So he's dealing with that. I don't think he's introducing some sort of broad, general, conspicuous unfairness test.
Well, in answer to one of my Lord Sumption's questions earlier, I recognise that the concept of conspicuous unfairness has been developed in the legitimate expectation field in circumstances.
It hasn't been adopted, except in one or two cases.
No, but insofar as it's used here by way of analogy to inform the way in which equal treatment questions should be dealt with, if that is the test that's being applied, I recognise that it has been developed and referred to in case law in circumstances where there has been reliance. And of course, that cannot be said to be the case in relation to the insurances here in relation to respondents. In any event, at 55, the Court of Appeal then says, in the light of that, it follows that, insofar as Mr. Justice Jacob purported to enunciate a general principle that was applicable in all contexts, it's in my view he was wrong to do so. And then he goes on to seek to distinguish what was said in NatWest. And I'll come back to that and refer to our case in relation to those matters. In essence, we say those points of distinction are neither right nor relevant here. We say that what Mr. Justice Collins was actually doing was looking at whether or not there was an objective justification and then considering the question of fairness. He didn't see it as an absolute rule. And we can see that if we turn on to page 240 in the bundle to the conclusion of his judgment. Paragraphs 50 and 51. So here he's dealing with the situation where he's recognising the principle of equal treatment applies, there is differential treatment by the OFT, but that difference in treatment is being justified on the basis of the mistake that he has identified. And he then says in 50, it seems to me that in circumstances, the principle that, as a general rule, a mistake should not be replicated, where public funds are concerned, should apply. That, in my judgment, provides an objective justification for the refusal by the OFT to make payment to the claimants. But he then goes on in 51 to actually talk about whether or not that is in the round unfair.
Would the position be any different if the penalties were not paid into the consolidated fund? Suppose that they were retained against administrative expenses of the public body in question. I find it hard to see that the fact that they're paid into the consolidated fund can make a great deal of difference.
No, I think that in relation to where precisely the monies are paid, whether they're paid to the consolidated fund or not, we accept is not.
The question is simply whether it's a public body exercising a statutory function.
Yes, I think that is undoubtedly right. Nothing from our point of view turns on whether it's paid to the consolidated fund. What we do emphasise is that the public authority is carrying out an important function in enforcing competition law, which is an important public operation set down under statute, and imposing penalties in that regard is something that Parliament has given it power to do. Quite where they are then paid to is not the critical issue here. So if we then go back to the decision of the Court of Appeal and pick it up at page 221, the Court of Appeal says, for all these reasons, which are distinguishing NatWest on the basis that, first of all, there was a strong expectation of equal treatment in 56 in this case, but not in NatWest, and we say a strong right or expectation is not material. The point is that in both cases, equal treatment principles applied. Second distinguishing factor was that there was a large administrative system, and we say that is not a material distinction when you're talking about mistakes in these circumstances. And as for the point that's the third point of distinction, that in NatWest it was a terribly complex legal issue and here it was actually very simple, that would result in a somewhat perverse outcome, that the more fundamental error that you made, the more you were required to replicate it, which cannot possibly be right. And we've described these issues in our statement at paragraphs at page 122, paragraph 46. But as I say, 59, we say, is not actually a fair characterisation of what Mr. Justice Collins did. He didn't simply apply the principle that blunders shouldn't be repeated as if it was an absolute rule. He considered it carefully as a general rule and considered it in the context of the particular fairness of outcome in respect of these respondents. There is then in 59 some discussion of the position in relation to 2008, but the core reasoning is actually found in paragraph 60. The real focus must be on the question whether the 2012 decision, so that's the decision to reach a settlement with TMR but not to make payments to the respondents, was objectively justified. That's when the OFT decided it would act on the 2008 decision in relation to TMR and honour the assurances that it had mistakenly given at that time and to treat the applicants differently. Now, what is striking about this paragraph is that although it says that the real focus must be on the question of whether the 2012 decision was objectively justified, actually there is no reference to and consideration of the objective justification considerations that the OFT is putting forward here. Those are the protection of principles of legal certainty and finality in circumstances where they're undermined by replicating a mistake. Instead, what we see is that although it says that the focus must be on objective justification, we see the court go on and say the result that it was that it agreed with TMR to repay the whole of penalty plus costs and interest, but it refused to pay anything to the appellants. The only difference between the positions of TMR on the one hand and that of the appellants on the other was that the OFT had given assurances to TMR in 2008, but not to the appellants. Well, to some extent, that's a description of the position. It tells you nothing about the objective justification consideration that's being put forward. And then the sixth sentence, it says, the effect of that manifestly unfair and unequal treatment in 2008 could have been reversed after the issue had been raised by ASDA and Party A, and the OFT's eyes had been opened to the significance of its earlier mistake in giving the assurances to TMR. Well, again, that is not telling us anything about the objective justification, but it's also completely speculative and without an evidential foundation. There was no such eye-opening moment. The OFT did not. When dealing with these two other parties, Party A and ASDA, who made inquiries in respectively 2009 and 2010, there is no evidence that the OFT had realised that it had made a mistake back in 2008 with TMR, and there's no evidence whatsoever that OFT personnel involved made any connection between these episodes, nor was there any suggestion made in the court below to that effect, nor did the High Court make any such finding. Had this point been argued at first instance, the OFT would have had opportunity to address evidence to refute it, and it was quite wrong of the Court of Appeal in those circumstances to make such factual findings. It just was not in a position to do so.
Well, it would have made no difference if it had been reversed, because the company would then have had an unanswerable case for an extension of time to appeal, and an unanswerable case for succeeding on that appeal.
Whereas Gallaher and Summerfield would not.
Yeah.
That is absolutely true if the withdrawals had happened at a point where it was after the time for appeal.
Yes, but this sentence is addressed to the situation once the balloon went up, as I
Yes, I think here though, I think one has to read on, because I think here they're actually contemplating the situation where the error is recognised before the time for appeal has elapsed.
Nothing?
Yes, because I think if one goes on.
It says it would not have been too late for TMR to appeal
exactly.
at that time.
Yes.
But then it actually goes on and makes the point that even if TMR had been out of time, it would have had a very powerful case for arguing withdrawal of the assurances as an exceptional circumstances which justified an extension of time for appealing. So all up to that sentence is assuming correction before the time for appeal, in respect of which there's no basis. They then reinforce the reasoning with the point that my Lord Sumption has just raised, which is just plainly wrong. So, as I say, the focus in this paragraph, this core reasoning is supposed to be about the objective justification. It proceeds on the basis of a series of speculative factual findings and then a sentence, even if TMR had been out of time, which is actually irrational in relation to the question that's being dealt with here. Because if TMR, as Lord Sumption has rightly indicated, had been had the assurances withdrawn out of time for appeal, it could plainly have appealed, and there wouldn't be a basis in relation to Gallaher and Summerfield on the basis of the Court of Appeal's own approach. And then it says, instead, the OFT acted on the assurances it had given to TMR, made the 2012 decision, and repaid the penalty previously levied. Well, again, this is a very strange phraseology. To say that the OFT was acting on the assurances is a funny way of expressing what happened, because it's not actually correct that the OFT acted on the assurances, in the sense that it didn't say, you get the benefit of the appeals, and it didn't actually withdraw the decision, which was what TMR had said it wanted. What the OFT did was it was realistic about the chances of resisting an out-of-time appeal, so it wasn't so much acting on the assurances as dealing with the fallout from the assurances in those circumstances. And then the conclusion is, in all the circumstances, this was a plain breach of the principle of equal treatment and unfair. Now, in that reasoning, there is no consideration of the objective justification question. Now, it doesn't matter whether or not you're talking about unfairness, conspicuous unfairness, or otherwise. There is clearly an issue here that the mistake that was made did mean that in the circumstances there was an objective justification for not replicating the mistake, for not further undermining principles of legal certainty and finality. And even if there is some qualification to that by reference to unfairness or conspicuous unfairness or abuse of power or whatever it may be, that is not a justified finding. And as it relates to fairness itself, it is worth bearing in mind that in relation to the respondents, as Mr. Justice Collins found, they had admitted serious infringements of competition law, were willing to accept the benefits of settlement, including finality and discount on penalty. They did, even after the decision was provided to them, of course they could have appealed, ASDA did, even though it was a signatory to the ERA. That would have entailed risks for them, but it was a matter they could decide upon. They were large commercial parties with expert assistance, and they took the decision with their eyes open, as the Court of Appeal in the out-of-time appeals case specifically said. The statements made to TM Retail didn't reflect any deliberate favouring of TMR or a special deal, but arose purely from OFT personnel's muddled thought process as to what would be expected of the OFT in the event of a successful third-party appeal. And the statements made to TM Retail were, and the replication of them in favour of the respondents would be, contrary to important basic principles which underpin the operation of the appellate system. So in those circumstances, there was no good basis for the Court of Appeal overturning the judge below in relation to the question whether there was an objective justification for departing from principles of equal treatment. And I would add, of course, that in relation to Gallaher and Summerfield, there was no detrimental reliance upon the assurances at all. Now,
in relation to the principles of finality and certainty, I find them a bit elusive, since it's a term of the agreement, each of these early settlement agreements, that you could actually abandon it and appeal. So it's not putting a line under things completely. Why shouldn't you enter into, I mean, it may be a very odd and a misguided agreement to enter into, but is there some fundamental objection to entering into the agreement which was entered into if they really thought it was appropriate to give away most of the advantages of the agreement and get just the advantages of a clear admission and the assistance provisions?
Well, I think clearly there are benefits to those aspects of the...
In other words, I don't know why we're looking at it in terms of this agreement with the TMR infringing fundamental principles of finality and certainty. It seems to me it can be just looked at as being misguided, certainly mistaken in that respect. I mean, clearly haven't thought through.
Well, the way it undermines principles of finality and certainty is not so much the early resolution agreement itself, it's the assurance undermines finality and certainty.
Right.
It's that which does it, not the ERA itself, and that is the objection.
Yes, but I mean, if they thought it was worth undermining, the thing itself, as I pointed out, has clauses in it which undermine finality and certainty, because you can appeal even once you've entered into it. So it's not really completely final. But
well,
anyway,
no. But that is true. But the appeals have to be through the statutory appeal mechanism.
Yes, of course.
You actually have to take the statutory scheme. And the key point in relation to finality and legal certainty is you have a statutory scheme that protects finality and legal certainty. You can only challenge through the appeal mechanism. The ERA doesn't vary that. No. You may say, well, actually, it gives people an awful lot of leeway, but it is still protecting the fundamental system that you can only challenge.
It doesn't have ex gratia elements, that's right.
No, absolutely.
Right, sorry, well, you're very short of time.
Yes, well, in those circumstances, we have, I hope, explained why it is that we say that the core reasoning here in relation to this judgment by the Court of Appeal is fundamentally flawed, because taking as its starting point the fact that there was a breach of equal treatment is only the starting point. It is not the conclusion. It required consideration of the objective justification. The court below did that. That it was entitled to do so. And if there is a caveat, if there is a further qualification to the principle of objective justification, here made manifest by non-replication of mistakes, that caveat, which must relate to broader principles of unfairness, we would suggest, is not met here. The other ground that we have pursued in relation to appeal, we've set out in our written case at electronic bundle pages 126 to 131. It is that actually the logically prior point that as between the respondents and PMR, they are not and were not in materially identical positions or should not be treated as relevant comparators. Now, in relation to the first point, the essential difference between them is that, as between Gallaher and Summerfield, the respondents, and TMR, of course, there was no detrimental reliance in relation to the assurances. And we have explained how there could not be said to be detrimental reliance that went to whether or not they decided to appeal, which was the critical reliance here. Because we say that both Gallaher and Summerfield decided not to appeal without any expectation of benefiting from a third-party appeal. It's clear, therefore, that the possibility of benefit from a third-party appeal was neither the proximate nor even the but-for cause of their decision not to appeal. And since we know that benefits from third-party appeals are not their causes of their decisions in relation to appeal, they can't now turn around and say, actually, they would have relied to their detriment in any event if these assurances had been replicated to them. So we say that there's a material difference, and of course I've shown you the evidence from TM Retail, or the correspondence where they articulate why it is that they did rely on the assurances in deciding not to appeal. Of course, in relation to the respondents, their evidence is, in fact, they wouldn't have expected comfort in relation to such issues. And I just refer you to the witness statements of Mr. Bingham and Miss Taylor for the respondents at pages 245, paragraph 15 for Mr. Bingham, and 251, paragraph 17 for Miss Taylor. So there wasn't detrimental reliance. In response, the respondents say two things. One is, well, we relied on the principle of equal treatment having been specified in the course of the ERA process, to which we say that is not the relevant reliance here. And Summerfield say it would have placed weight on the assurance in deciding not to appeal. The assurance might have been a factor in the decision and provided a further reason not to appeal. Well, as I say, that is not in the circumstances determinative, in circumstances where it's clear that the decision that Summerfield would have been reached anyway. And so none of this puts either Gallaher and Summerfield in the same position as TM Retail. We cite in support of the fact that...
Depends what you mean by reliance, doesn't it? I mean, I suppose if they'd known about it, it might have been an additional factor which encouraged them. But you say it's not a factor which would have made any difference, because we can see that.
Yes, yeah. That's essentially it. And we say that detrimental reliance, it can be a relevant consideration for delineating different groups when you're applying the principle of equal treatment. We cite the Healy-Hutchison case, which is Authorities Bundle 1, tab 7, page 979, and I would refer the court there in particular to paragraph 17 and 18, where it indicates that the distinction between the two groups being compared there was detrimental reliance, and paragraph 64, where the Court of Appeal made clear that on principle it's not enough to say that the persons to be treated in the same way were in the same cohort originally. It's necessary to look at the time when the decision's made, that is, when the decision maker is called upon to assess whether they should be treated as being in the same position. So we do emphasise in relation to what is our ground one, as a matter of logic, but dealt with second in our written submissions, that there is a distinction there. And the final point we raise in relation to comparators is that, of course, what we do know now is that there were parties, in particular Party A and ASDA, to whom none of these assurances were made, even though they made inquiries about the impact of third-party appeals. And we have set out in our written statement why it is that there would be no unfairness to compare with Party A and ASDA rather than with TM Retail as the relevant comparator. We recognise, of course, that when you're engaged in assessing comparison for the purposes of equal treatment, it is not simply a numbers game, but where in this case you have an outlier a mistake having been made in the crucible of complicated and time-pressed negotiations, whereas the considerations of Party A, of the responses in Party A and ASDA were given after fuller consideration, then in those circumstances, TM Retail is not the relevant comparator for that reason either. I'm conscious of the time. Unless I can assist the panel further, those are our submissions.
Thank you very much. Andrew?
I have nothing to add. Thank you.
Thank you very much. Yes, Lord Panic.
Thank you very much, my Lord. My Lords, there are 4 topics I want to address. First, the legal test. Secondly, I want to say something about the background facts. Then I'll try to deal with the objective justification relied on by the CMA. And finally, the submissions my friend has just made on why he says TMR and Gallaher were not in a comparable position. Your Lordships asked my friend about the relevant legal principles governing equal treatment and substantive unfairness. The Court will have seen from the judgments below that this issue was not the subject of detailed analysis by the courts below, and that's because the CMA accepted, and rightly so in my submission, that if, on the facts, Gallaher and TMR were in a comparable position, then it was for the CMA to satisfy the court that there was an objective justification for the difference in treatment. But since your Lordships ask about the matter, I say there are 2 principles of law which do overlap. The first principle of law is the principle of equal treatment. A public body must not treat a person less favourably than a person in a comparable position without an objective justification. And I'll show your Lordships the authority in a moment. But secondly, there is additionally, separately, a principle of public law of substantive unfairness. Now, those principles overlap, particularly in a case such as this, and they overlap not least because the more unfair the treatment of Gallaher or Summerfield, the more difficult it is for the CMA to show an objective justification for the difference in treatment. The court doesn't look at objective justification in the abstract. If there is substantive unfairness, the court will be less willing to say that the justification, that an objective justification is shown. And of course here, the Court of Appeal was satisfied, having looked at all the circumstances, that there was very substantial unfairness. Lord Dyson, for the Court of Appeal, paragraph 59, I don't ask the court to turn it up because the court's read all this, it's MS 221. Lord Dyson said the unequal and unfair treatment was stark and manifest. Paragraph 60 at MS 221, Lord Dyson said it was manifestly unfair and unequal treatment. It was a plain breach of the principle of equal treatment and unfair. Now, these two principles, equal treatment and substantive unfairness, are different because it is, of course, possible, very possible, to have a case of substantive unfairness which is not based on a denial of equal treatment. And there are cases in the books of that, and I'll show the court one in a moment. And of course, in this case, we rely not just on our right to equal treatment, we rely also on the promises we were given by the OFT and on our reliance on them. And I'll show you, Lordships, the evidence on what our reliance was. Now, in relation to these 2 principles, first, equal treatment, my Lord Hodge has already drawn attention to the foundation in modern law of this principle, which is Lord Scarman's statement in Federation of Self-Employed. I don't go back to it. My Lord has directed attention to it. It's MS 1696, Volume 3, Tab 25. And there are examples in the books, many examples, of a principle of equality being applied in public law. A good example, I say, is the National Lottery case, National Lottery Commission case. Can we just go to that briefly? It's Volume 3, Tab 28, and it's MS 1750. MS 1750, Volume 3, Tab 28, Queen against the National Lottery Commission, ex parte Camelot. And your lordships will recall, because my friend referred to it, what happened here was that the Commission was considering bids to run the National Lottery. And there were two bidders, two main bidders, and what the Commission did was to decide that neither of them met the criteria, but it would allow one of them, the Richard Branson bid, an opportunity to respond to the Commission's concerns, but it gave no such opportunity to Camelot. And Mr. Justice Richards set out the relevant principle at MS 1779. He made a finding at paragraph 70 that this was conspicuously unfair. And at 72, his lordship said, I find it remarkable that in the circumstances the Commission chose to allow TPL the opportunity to allay its concerns, but to deny a similar opportunity to Camelot. Such a marked lack of even-handedness between the rival bidders, who plainly were in a comparable position, calls for the most compelling justification, which I cannot find in the reasons advanced by the Commission.
Are you in a comparable position? I mean, this was a competitive bid. It was, so to speak, a zero-sum game. The complainants were necessarily worse off by virtue of the favour shown to Virgin. The facts are different here.
The facts are, of course,
your clients
each
are not
case
worse.
depends upon
Your
its own
clients are
facts.
not worse off at all by virtue of someone else being given a benefit they shouldn't have had.
No, but we're worse off in this sense, my lord, that we have been promised equal treatment, we're entitled to equal treatment, a benefit that is relevant to the ERA and closely linked to it has been given to one of the other 12 concerned persons, and that benefit has been denied to us. We have therefore been denied a benefit to which we were entitled under the principle of equality. That's the unfairness, that's the breach of a lack of equal treatment. I entirely accept it's not the same as Camelot, but that's because each case in relation to equal treatment is going to depend on the particular circumstances of the case. And the question for the court is whether in all the circumstances of this case there is a breach of equal treatment and whether there is substantive unfairness. I show the court the Camelot case as an example, which your lordships were interested in, of the principle of equal treatment being applied in public law. That's its relevance. The principle of equal treatment is also applicable, as my friend accepts, because of Section 60 of the Competition Act. If your lordships would go back to...
Well, there's a certain artificiality here, isn't there, about looking at this in separate intellectual stages. Is there a breach of the principle of equal treatment? Is it objectively justified? Is there an exception to the principle of objective justification? I mean, essentially what you're saying is the principle of equal treatment entitles us to the benefit of the same mistake that was made with regard to TNR. And I just wonder whether the principle of equal treatment extends that far without having to look at it in terms of breach plus objective justification.
Well, one can only establish a breach of equal treatment by showing two things. First, that you are in a comparable position to the benefited party, and secondly, that there is no objective justification for the difference. And the main point between us is that my friend says that a mistake was made and that there is an objective justification in that we have no right to have it replicated to us. And I'm going to develop my argument as to why we are in a comparable position. We have a strong expectation of equal treatment. And
no, but you didn't have an expectation of this. did you? You had your expectation was that everyone would be treated like you.
We had an
in which case you would certainly not get the monies back now.
No, we had an expectation. I entirely accept we didn't have an expectation that we would get this benefit,
yes.
But we did have an expectation that whatever benefits were given to the other parties, to the ERAs, would also be accorded to us. And I'll show you, Lordships, if I may.
Right, well, of course, we have seen that, but it does come back to the point that does an expectation or does a principle of equality extend to replicating errors, in particular in your case, when it's might be thought of as a complete windfall, since you didn't even ask for this or expect it, contrary to TMR, who at least had a case for saying that they wouldn't have entered into the deal at all without this consideration.
Well, I'll show you, Lordships, the evidence. The evidence is that we didn't ask for it because we were told that anything that was given to others would be given to us,
yes.
And that the principles of the ERA were non-negotiable. That's
yes.
why we didn't ask for it. But it's a question for your Lordships, having looked at all the circumstances, whether the argument of mistake is a sufficient objective justification for the difference in treatment in all the circumstances.
Can I ask a different question? I mean, you've accepted a moment ago that your clients aren't worse off. Is that in fact so? I mean, in a sense, giving a particular company a windfall by mistake, giving TMR by mistake a windfall repayment, puts them in a better financial position than you if you don't make an equivalent windfall recovery yourselves.
That is true, but I would have to accept that we're not in direct competition, unless I'm told to the contrary by those behind me, because TMR were a retailer,
yes,
and we're a manufacturer.
Yes.
So I don't want to take a bad point.
Well, that's very fair, Lord Panic.
It may be an argument that's open to the court, but not to you.
Well,
we might in some
you
circumstances.
should appreciate that is the position. We're a manufacturer.
Yes, of course.
Yes. TMR are a retailer. But my argument is that very often in the context of equality, one is seeking something to which one otherwise has no entitlement. That's the whole point of the principle of equality. And we're entitled to say that a benefit, a very substantial benefit, relevant to the ERA, was given to TMR in circumstances where we're all promised equal treatment, and then we find that something has been given to one party, to the ERA, which is not given to us. But I need to develop these points, and I will if I may. Can I just finish the submission on the legal principles which your Lordships were interested in? Equal treatment is also a fundamental requirement on the OFT, as my friend accepts, under Section 60 of the Competition Act. If your Lordships would please go back to Authorities Volume 1, Tab 1, it's page 722, MS 722, to which my friend referred. The Lordships have already seen Section 60. What it requires is that when the OFT, see Section 60, subsection 4A, applies Part 1 of the Competition Act, it must comply with the principles of EU competition law. That's the substance of it, as my friend has accepted. And there is no dispute that it is a fundamental principle of EU competition law that there must be equal treatment. And my Lord Palmworth asked for an authority for this. The authority is the Cone case, which your Lordships have in Volume 3 at tab 35. It's MS 1935.
You submit that subsection 2 extends beyond the substantive principles of law, do you?
I'm sorry, Mal, I didn't pick up the question.
Are you submitting that subsection 2 extends beyond the principles of competition law and extends to the procedural processes by which decisions are made?
Yes, my Lord, because the under this part 1, we're concerned with the imposition of penalties, we're concerned with investigations, we're concerned with all the powers of the OFT as it then was under Part 1 of the Act. So it's not simply with the question of is there a breach of competition law. And my friend has accepted that, and so has the Court of Appeal. I'll come to the authority of the Court of Appeal. But the principle of equal treatment in EU law, as I say, is Volume 3, tab 35, page MS 1935, and the relevant paragraph in that decision, Cone OYJ, is at paragraph 97, which your lordships will find on MS page 1962. And the court there sets out at paragraph 97 the basic principle. The principle of equal treatment as a general principle of EU law requires that comparable situations must not be treated differently, different situations must not be treated the same way, unless such treatment is objectively justified. And they refer to an earlier case which makes clear there's an onus on the respondent, on the public body, to show an objective justification. And this has been applied by our Court of Appeal in the Argos and Littlewoods case. It's Volume 1, tab 3, at MS 734. And the Court of Appeal then applies this principle of non-discrimination starting at MS 797, where they set it out. I don't think I need to read all that out, but I would draw attention to paragraph 280, which is at MS 827. And they're dealing with equal treatment in the context of a penalty judgment. And they say at paragraph 280 on MS 827, it seems to us the principle of equal treatment requires that if two undertakings in comparable circumstances have been dealt with in unlike ways, the difference of treatment is wrong in law unless and except to the extent that it is objectively justified. If it's wrong in law, then the less favoured undertaking is entitled to appeal, have its penalty reduced to the extent necessary to eliminate the inequality of treatment. We do not think it's necessary to show manifest injustice in addition to such an unjustified difference of treatment. So the question is unjustified difference of treatment. The question is not manifest injustice. Now, the separate principle, although overlapping principle in some circumstances of the public law test of substantive unfairness, that is seen in particular in the Unilever case. If your lordships would go to volume 3, tab 26, MS 1710. And what had happened here was that the revenue for many years had adopted a practice in relation to loss relief. And one year they changed their approach without any prior notice to Unilever, causing a detriment to Unilever. And the revenue said there was no legitimate expectation, they hadn't given an assurance, and therefore there was no public law wrong. And your lordships will see, picking it up at MS 1718, that at letter J, Mr. Alan Moses for the Crown subjected the judge's decision. It was Mr. Justice Macpherson who did not readily find unfairness, but he did in this case. Mr. Alan Moses subjected the judge's decision to a close and searching criticism. The main lines of his criticism are then set out, and one of them is over the page, MS 1719. Mr. Moses submitted at just by letter A there was no clear, unambiguous and unqualified representation by the revenue, such as was held to be necessary in the MFK underwriting case. And then there's a number of other points that Mr. Moses set out in his argument. And at E, Sir Thomas Bingham, Master of the Rolls, said that he would in general terms accept almost all these points. They reflect high authority. They rest on sound legal principle, but his lordship was very uneasy at the conclusion which the argument is said to compel in this case. Unilever was entitled to make a number of points on the facts of the present case. First, and I so submit, the courts have not previously had occasion to consider facts analogous to those here. The categories of unfairness are not closed. Precedent should act as a guide, not a cage. Each case must be judged on its own facts, bearing in mind the revenue's unqualified acceptance of a duty to act fairly and in accordance with the highest public standards. And then his lordship set out the facts of the case, and at MS 1720, letter G, his lordship concluded that the points cumulatively persuaded his lordship on the unique facts of the case, the revenue's argument should be rejected. On the history here, his lordship considered to reject Unilever's claim in reliance on the time limit without clear and general advance notice is so unfair as to amount to an abuse of power. Now, again, I don't say our case is the same on the facts. I draw it to the court's attention as an example of a principle in public law of substantive unfairness. Another strand of substantive unfairness in public law is, of course, in the context of a breach of substantive legitimate expectations. And my Lord Carnworth has analysed the development of the principle of substantive unfairness in the context of legitimate expectations in my Lord's judgment in the Privy Council case of United Policyholders Group. It's volume 3, tab 33, starting at MS 1900. And I won't take time on that, but I draw it to the attention of the court. I should also mention, in the context of legitimate expectations, your lordships may just wish to note volume 2, tab 16, MS 1294, which is the Papanet case. And if your lordships would go in Papanet to MS page 1305, this is substantive. Yeah. This is a case about substantive legitimate expectations. At MS 1305, in the judgment for the board of Lord Dyson, paragraph 28, his lordship quotes from Lord Hoffman's summary of the relevant principles in the Banku case. And Lord Hoffman said, it is clear in a case such as the present, a claim to a legitimate expectation can be based only upon a promise which is clear, unambiguous, and devoid of relevant qualification. It is not essential that the applicant should have relied upon the promise to his detriment, although this is a relevant consideration in deciding whether the adoption of a policy in conflict with the promise would be an abuse of power, and such a change of policy may be justified in the public interest. So it is not the case in the context of legitimate expectation that one must always show detrimental reliance. That is relevant, but it is not determinative. It's not challenged. So those are the relevant principles of equal treatment and substantive unfairness. In my submission, the strength of a complaint under each of these two heads must depend upon all the circumstances of the particular case. And may I very briefly just remind your lordships of the circumstances of this case that are relevant to assessment of what is said to be the objective justification for the difference in treatment. The first point is that the OFT itself recognised in its policy documents that equality of treatment between the various companies who were the subject of the competition inquiry was fundamental to the ERA process. And your lordships have the policy document in the core volume, MS 313. This is their internal policy document, which was the foundation of what they told Gallaher, Summerfield and all the other companies. MS 313, it's headed sensitive policy, and it says a principled approach to settlements in Competition Act cases. And may I draw the court's attention, please, to MS page 316. In the middle of the page, your lordships will see Principle 3. Fairness, transparency and consistency are integral to an effective settlements process. Paragraph 16, the overriding principles of fairness, transparency and consistency must always be taken into account. 17, consistency is a particularly key consideration, given parties' sensitivity to equality of treatment issues. Whether or not the details of an individual case have been made public, particular approaches in one case will inevitably leak out during the settlement process or afterwards and be set out in the infringement decision and inform parties' strategies in others. Consistency of approach, or alternatively the formulation of strong arguments to justify taking a different approach in similar circumstances, is therefore vital. In line with EPD principles, that means effective project delivery principles, in light of the considerable knock-on effects that settlements may have, particularly at this nascent stage in their development, API, that's the Advisory Policy International Division of the OFT, API should be involved early when settlements are being considered. So consistency for the OFT was absolutely essential.
Are you saying, I think you probably are, that adds something to what would be the ordinary duty under public law anyway?
Yes, I say that there is equality obligations, but this is a much stronger case when your lordships come to ask, is there an objective justice?
You seem to be saying, you're sort of piecing together equality and legitimate expectation and saying here the OFT is not subject anyway to a principle of equality, but they've given us an expectation.
Yes.
They will imply it with particular rigour.
Most definitely. It is their policy and it was communicated.
And that is comparable to a practice of the revenue or something like that?
Yes.
What is the status of this document, Lord Panic?
It is their internal policy document, which was not published,
No.
but it is the basis for what they did tell us, and I'm going to show you.
Yes, but insofar as one is building up a case of or analogous to legitimate expectation, we need to see what they told you.
Oh, indeed,
not
indeed.
what they've said here. So
No, I entirely
we're not parsing this document as the basis for an expectation.
No, I entirely accept that, but it is, I say, an important document
Yes.
because it shows the court the foundation of what they did tell us, and it tells your lordships just how important equality of treatment was in the ERA context. The position taken by the OFT, and understandably so, was that if you are going to have an effective ERA process, it can only work if you, the OFT, act consistently as between the parties. That's their approach. And they repeat this, if we turn on in the document, paragraph 34, it's MS 320, middle of the page, paragraph 34. At the same time, it's crucial the following factors are taken into account. And the second bullet point is the need to ensure consistency, transparency as far as possible, the need for equality of treatment as between the parties, but also having regard to any relevant differences between them. And then finally, in this document, MS 324, paragraph 54, paragraph 54, it's the second sentence. One issue worth noting up front is the importance of adequate advanced preparation and detailed record keeping. Detailed record keeping to ensure consistency and equality of treatment is greater and in a more complex task in hybrid cases. And a hybrid case is defined in paragraph 52. That is cases where some parties, but not all of them, are willing to settle, or maybe they're willing to settle in respect of some infringements, not all. And that was this case, of course. So that's their policy document, and consistently with what they say at paragraph 54, they did keep records, because your lordships may have seen at MS 345, and the details don't matter, but your lordships can see the heading. It's a bit difficult to read, that the heading is the Early Resolution Consistency Table. And what they did was they kept a record of each discussion, what their response was, and what action they needed to take in order to ensure consistency.
But I mean, this is internal guidance.
Yes, it is.
It's obviously very desirable
Yes.
for them to give their officials guidance. They've got to be consistent.
Absolutely.
But
where
that doesn't help you, as my lord is saying. What we need to know is what you were told.
And that's what I'm coming to.
Yeah.
But what they told us is based upon their own policy. And what they told us was that equal treatment would be guaranteed for the parties. We have their speaking notes, which is 343, MS 343, when they came to meetings with the parties. And one of the matters that they told us, it's the last point on page MS 344. Once the first party signed up, the OFT will inform other parties of the terms agreed, terms of the penalty calculation. These terms will be the benchmark for dealing with other parties. The OFT will observe equal treatment principles. So that was their speaking note, and the evidence is that when they met with Gallaher, and Summerfield is the same, when they met with Gallaher, they emphasised that they would comply with equal treatment. The witness statement is MS 250.
Just before you go there, I'm sorry, I've missed your statement that they would observe.
Yes, I apologise, my lord.
My fault, I'm sure.
The relevant passage I was...
Which page are we going to be on?
We were on, let me just go back to...
343 and 4.
343 at 344, and it's...
343 has something at the bottom, and 344 at the end.
Final point.
I've got it in brackets at the very end.
Yes.
Yeah.
And when they met with us, that's what they told
He
us.
just says they'll observe. Yes, but I mean, that doesn't help you on the enhanced equality test. It simply says that they will observe their public law duty to be for equal treatment.
They would
I
treat...
thought you were building up a case for a sort of enhanced equality test based on their internal document.
No, I'm not doing that. I'm simply showing your lordships that they recognise the importance in the context of ERAs of treating the parties equally. And they emphasised, when they met with us, that that's what would happen.
Tempting to say the fact it's in brackets is it was an explanation to the speaker rather than something he would actually say. But maybe I'm being undue.
Well, I wondered whether 343, 5 lines up, was
Yes.
more to the point, dealing with Lord Carver's point.
The third bullet point from the end.
Yeah, third bullet point from the end.
Yeah.
Reserves.
Provided these are consistent between
That's
them. Well, I'm
simply
grateful,
saying what is
yes.
their public law duty. They can
Yes.
Yes. But they were aware of it, and they
I know,
emphasised
I mean, that's common ground,
No.
that they were observing consistency and equality. But you were trying to argue for an enhanced equality test.
Well, I say, in the circumstances of this case, they emphasised to us that that's what would happen, and we relied on it, and I'll take your lordships to the reliance in due course.
Enhanced because it's uttered. It's
Yeah.
made express.
Indeed. And this is important in the context of what we thought the process was going to involve. At 250, MS 250, your lordships will see part of the witness statement, which begins at MS 247, of Isabel Taylor, a partner in Slaughter and May, who was representing Gallaher. And at 250, she refers to her notes of the meeting with Sonia Branch of the first meeting, and she says at the top of 250, MS 250, including in the opening remarks, was a statement by Ms Branch, the OFT was prepared to be pragmatic, but there is an equal treatment issue. I understood that statement to mean the OFT was obliged to would give equal treatment to all parties with whom it was discussing early resolution, that all the terms of the early resolution arrangements, which at that stage had not been documented, would be the same for all parties, save where there were fact-specific differences for any party. The statement did not surprise me, as it confirmed my expectation of how the OFT would approach the early resolution process. I and believe my colleagues, Ms Aldrin May, relied on that understanding and proceeded on that basis throughout the early resolution discussions in which we represented Gallaher. And it wasn't simply that that's what they told us, that's what they did, because if your lordships go to MS 392...
Just be clear, the statement that's being relied on is that the OFT was prepared to be pragmatic, but there's an equal treatment issue.
Yes.
Yeah, okay.
Which is really saying, we're happy to negotiate directly with you, but there may be very great limits on giving you any special deals.
That each party would be treated in the same way. That each party would be treated in the same way. And what they meant by that is shown by MS 392. If your lordships would go to MS 392, which is an email from Mr. Louis Christofides, about a third of the way down the page, and it's sent on the 8th of July, and it's sent to Mr. Louveau, who's at Scotland now. Dear Bertrand, as mentioned over the phone just now, consistent with the principle that we would pass on to your client the benefit of developments in the early resolution process, we write to let you know that we propose to make a minor change in the description of P&D, as parity and differential infringements in the appendix to the ER agreement in order to follow more closely the formulation of the infringements in the statement of objections. And then they set out the detail, and then they say, as the OFT is yet to sign the ER agreement that your client sent back to us, we do not consider any formal variation is required. Instead, we propose, if it's acceptable to your client, we simply substitute in the agreement a revised appendix incorporating the above changes. So we've, by that stage, signed an ERA, and they write to tell us that because there have been changes agreed with others, they are going to give us the same changes consistent with their policy and their promise of equal treatment. And it's on the very same day, the 8th of July, notwithstanding their policy, notwithstanding their assurances, notwithstanding the implementation of it on that very day, that they reach agreement with TMR on a matter of some considerable importance, which is not handed on to us. That's what's so striking about all of this. Now, the assurance that he's given to TMR does not come out of the blue. It's not unconsidered in any sensible respect. The assurance given to TMR arises because of what TMR say to the OFT at MS page 360. And MS 360 is the agenda for the meeting on the 8th of July. And this is TMR, they're also known as MMRG, but they're the same people. They send an agenda for the meeting, and at paragraph 2, they set out other key outstanding issues, an understanding of the OFT's likely course of action as regards parties who've entered into an ERA, should either a manufacturer or a retailer who has not entered into an ERA subsequently be successful in overturning on appeal part or all of the OFT's decision against that manufacturer or retailer as regards liability or penalty. And that's dated the 4th of July. And that leads to the meeting on the 8th of July, the minutes of which, the notes of which, not minutes, the notes of which are at 373. And your lordships see at 373 the notes of the meeting. These are the OFT's notes of the meeting. And the attendees include Mr. Morris, Queen's Counsel, who's acting for TMR. They include Sonia Branch, who, as your lordships have heard, is the senior OFT person responsible for the ERA process. And your lordships may wish to note at 373, just before the part that is blacked out, SB, that's Ms. Branch, explained that unfortunately, after meetings with senior colleagues in policy, we've had to provide TMR with a revised penalty. The change was necessary to ensure equality of treatment between all parties and had been necessary following associated discussions with another party. So again, equality of treatment is absolutely vital to the OFT. The relevant part as to the assurance is at 377. At the top of the page, SM, that's Mr. Morris, puts his point about what happens if there's a successful appeal. Under the part blacked out, MMRG, that's TMR, then leave the room while the OFT consider the points they'd made. And on their return, SB, that's Miss Branch, noted the following: a successful appeal on liability would result in no finding against MMRG, that's TMR. In terms of a successful appeal on penalty, OFT would apply any reduction to MMRG. And as your lordships have heard, 2 days later, TMR sent an email setting out their understanding of what had been said at the meeting, that's MS 399. And there's no dispute that although Miss Branch receives the email and considers it, she chooses not to reply to it. She certainly doesn't contest TMR's understanding of what had been said at the meeting. Despite all that the OFT have told themselves and have told us about equal treatment, they don't inform us that the assurance had been given to TMR, and they don't seek to extend the assurance to us. And that is extraordinary in my submission. The actual ERAs that are agreed with all the parties, by which I mean Gallaher, Summerfield and TMR, and as far as I know everybody else who entered into an ERA, are in materially identical terms, apart from the description of each party's alleged infringement and the quantum of its penalty. And we can look at one ERA, for example, Gallaher's. It's MS, if we go into volume 2, it's probably the best place to find it. Volume 2 of the appendix, that is, part 2 of the appendix. It's MS 616. And your lordships, I know, have already seen this, and it sets out the obligations of Gallaher to cooperate if it enters into an ERA. It sets out the reduction in penalty that it will receive. But most importantly, on MS 619, this is part 2 of the appendix. MS 619.
Sorry, I'm trying to find the bundle you're referring to.
Your lordship should have an appendix part 2.
Well,
No.
Your lordships don't have that.
Well, I've got appendix to the Statement of Facts and Issues, Part 2.
This document appears in 2 places.
It will be in the appendix to the Statement of Facts and Issues
Yes,
as
your
well.
lordships will also find it at 353, yes. If your lordships go to the core volume part 1, which your lordships do have, 353. And your lordships see there, in the substance, paragraphs 1 to 6, it sets out the obligations of Gallaher when it enters into an ERA, in particular to
Page
cooperate.
353.
Yes,
At 354.
MS 354
No, this is back.
is a letter from the OFT, and over the page is the substance of the ERA, starting at 354. And paragraph 1, Gallaher admits its involvement. Paragraph 2, it will maintain continuous and complete cooperation. And 3 sets out the details of the cooperation that you have to give if you enter into an ERA. I don't think 4 or 5 matters. And at 6, right at the bottom of the page, we're told that a reduction of up to 20% is available for procedural cooperation with the OFT's investigation. And then the penalty is set out, and that's reduced by entering into the ERA. And then 7, in relation to the infringements, if Gallaher brings appeal proceedings before the CAT in respect of the OFT's decision, the OFT reserves the right to make an application to the CAT, A, to increase the penalty imposed on Gallaher, and B, to require Gallaher to pay the OFT's full costs of the appeal, regardless of the outcome of the appeal. So there is and deliberately so, and I don't complain about this, there is a real incentive from the OFT to Gallaher and the others to sign an ERA. That's the whole point of it. The OFT wants parties to sign ERAs. And the point is that TMR were given an assurance closely related, inextricably linked to a term of the ERA. That's paragraph 7, because they were told you will get the benefits of the ERA and you will get the benefits of the appeal without suffering the disadvantages of appealing that are set out in paragraph 7. That's what this case is all about.
May Miss or Mrs. Branch have thought that it was something that followed as a matter of law. All the others would be in the same position.
Well, let me tell
What
you.
was she? It depends what she was trying to do, but she was trying to presumably reflect, was she, the legal position rather than some policy decision?
Well, her evidence, and my friend Mr. Beard took the court
Yes.
to it this morning, is that she gave no serious thought to the matter as to the law. She doesn't say, I thought as a matter of law that TMR were entitled to this anyway. My friend took the court to
Well,
it.
if
It
she
was
gave no
against-
thought to it, I mean, she must have assumed it was an okay thing to do.
But I think someone said this morning, there may have been an element of hubris because they were expecting the appeal would fail.
Well, indeed. She sets out her understanding at MS 291.
She wasn't being asked to give a special assurance to TMR by the agenda. The agenda was just a sort of neutral question about how the OFT will deal with people who enter into ERAs if there's a subsequent successful appeal.
She was being asked, how will you treat us?
Well, not us, it's all parties. That's what the agenda says. In other words, she's not being asked to give a special assurance to TMR. She's being asked how the OFT will deal with people, which would include TMR if they do a deal, who do a deal if there is subsequently a successful appeal.
Your Lordship, of course, is correct that she wasn't being asked what do you think the legal position is, because she's not legal advice to TMR.
No.
Indeed, they have their own lawyers to give them legal advice. And her evidence, which my friend rightly took the court to at MS 291, is that she wasn't thinking about the legal position. She doesn't say, I consulted the legal advisors at the OFT. The Lordships can assume that there are plenty of them. as to what the legal...
She must have assumed that this was the right way to treat the parties.
The right way, not necessarily the legal obligation on the OFT.
Yes, but the point being made to you is that this isn't a discriminatory policy. It's worked out as being discriminatory because when the problem actually arose in concrete form, it was appreciated that those who hadn't had assurances were entitled to be treated in accordance with the law, i.e. to be stuck with the agreement.
Well, she's giving a specific assurance to a party on a matter closely linked to Clause 7 of the ERA, on a matter of some significance, in a context where she has promised all the parties equal treatment and where she and the OFT generally have come back to the parties, and I showed your lordships an example and said, we've got to treat you equally because we've given something to somebody else. And she's not replicated that assurance to the others. And the question is whether there is an objective justification for the difference in treatment. And the objective justification that is presented is that this was a mistake. She didn't understand what the proper legal position is. Now, the starting point here in my submission is what was said by Lord Dyson for the Court of Appeal in the judgment at paragraph 53, which your lordships will find at MS 219. And his lordship noted at paragraph 53 the starting point was that the parties were in disagreement as to the applicable principle, but then they came to an agreement. If one picks it up in the 7th line, it became clear during oral submissions, this is paragraph 53, that the differences between the parties were less stark, and in my view, says Lord Dyson rightly so, it was accepted that the question whether there was objective justification for the less favourable treatment of the appellants compared to the TMR depended on whether the difference in treatment was fair in all the circumstances. Mr. Beard accepted that the fact that a decision by a public authority is mistaken is not a trump card, and my friend repeated that this morning, which will always carry the day so as to permit the authority not to replicate the mistake regardless of the circumstances. For the appellants, that's Gallaher and Summerfield, it was accepted that the question is whether there's been unfairness on the part of the authority having regard to all the circumstances. The fact that there has been a mistake may be an important circumstance, it may be decisive, it all depends. And it was in that context that his lordship, Lord Dyson, referred to the principle in the context of legitimate expectation. Not that he was saying at 54 that this is a legitimate expectation case, but his lordship drew attention to the fact that a mistake, again, is not a trump card in the context of legitimate expectations. It may or may not be a decisive factor. So the question is whether in the circumstances of this case, the fact that Miss Branch was mistaken in some sense, does that provide the basis for an objective justification? And we draw attention to a number of factors. First, we say that it is relevant that this assurance was given by the most senior responsible OFT official after consideration of a point that had been raised by TMR previously in the agenda. Miss Branch, her status is set out at the beginning of her witness statement. It's MS 279. Beginning of her witness statement, MS 279, it's paragraph 2, where she says that in July 2007, she'd been appointed as the senior responsible officer on the tobacco case. She was responsible to the executive for the overall conduct and delivery of the case. She says, I was the decision maker for the tobacco statement of objections and supplementary statement. I was in charge of conducting the early resolution process. So this is not some junior official. This is the central person at the OFT who is dealing with the ERA process. That's the first point. The second point I make as to whether a mistake provides an objective justification in the circumstances of this case is that the CMA do not suggest, my friend does not suggest, that the OFT lacked legal power to offer the assurance to TMR in 2008, or that it was otherwise unlawful for the OFT to give this assurance. Lord Dyson made this point for the Court of Appeal at paragraph 54. It's MS 220. It's line 3 of paragraph 54 of MS 220. I should make it clear it's not suggested it's ultra vires for the OFT to act in breach of the equality principle. Now, it is true, and I accept...
That's a slightly different point, though, isn't
Yes,
it?
the opposite.
Does he mean to act as they did, or just not generally, that
No,
the
he
breach of
means
equality
to act as
doesn't
they
go
did.
to varies?
No, he means to act as they did.
Well-
he can't mean...
Well, why not?
Because that was the concession, that, if concession's the right word, that was being made. It's clear, it's not suggested that it's ultra vires for the OFT to act in breach of the equality principle. In other words, to have given an assurance to TMR.
Well, to have given an assurance to TMR and not given
Yes.
it to others. I mean, what he's focusing on is the breach of the principle.
I take your lordship's point. And
He does elsewhere. He does elsewhere say, doesn't he?
He
That
does.
The assurance given in the light of the certainty principle was one which no reasonable public body in the position of the OFT could properly have given.
Well,
I think.
yes, he does say that, and I, with great respect, would say that's not correct. For this reason, my lord, for this reason.
But it just colours it colours one's understanding of what he's saying here. I mean, it may be right or it may be wrong.
Yeah.
But he wasn't saying it's a perfectly okay assurance to give if it had been given to everybody.
I take your lordship's point, and I don't need paragraph 54. My point, and let me restate it, is I say, and my friend has not disputed at any stage during these proceedings, that Miss Branch had lawful power to offer this assurance to TMR. It was not unlawful to give TMR an assurance that should...
Well, if it was irrational, it was unlawful. He's saying it was more than... it's not suggested that it's more than unlawful. In other words, that the power to do it didn't exist at all.
Well, let me deal with whether it's irrational in a moment. It was certainly, I say, within the powers of the OFT to offer TMR an assurance to which they had no legal entitlement. And let me try to make that good. What I mean by that is that the law clearly establishes, and my friend has shown the court the authority, that the fact that Party A appeals and succeeds does not entitle Party B, who has not appealed, to come forward after the time for appealing has expired and to seek the benefit of the judgment. That's the wood pulp principle. That's Deutsche Bahn. And I entirely accept that. But that does not mean that the OFT lacks a power to say to a party, we will agree to confer upon you the benefit of a judgment after an appeal by others. There may be good practical reasons for a person in the position of the OFT to do that.
Where do we find the OFT's powers to enter into these early settlement agreements at all? Are they somewhere in the Competition Act? Is it just emerged from practice?
It emerges from the practice. The provisions of the Competition Act deal with the setting of, they deal in section 25,
Do we have that?
power of the CMA to investigate, and the Act deals at section 31 with decisions following an investigation. The CMA must give written notice.
Can you give us page?
And section 36 deals with penalties.
No, but do we have all these?
No, your lordships
I
don't.
don't think we did. We just got section
But
60.
I have, if your lordships are interested, I can hand up copies of...
But they don't tell us.
Is there a specific power to horse trade?
No, of course not.
I mean, it's got to be, if it's not spelt out, it's got to be treated as incidental to some other power that they do have.
Yes, well, as a
I think
public
it's like the
body.
revenue care and management. They've got power to negotiate settlements.
Of course. And they have power.
Where, which, is that a specific section, the power to negotiate settlements?
In
In the revenue?
No,
the revenue, yes.
I thought it was inherent.
But they have it
Neither
section
party,
54
or none of the
TMA.
parties, are, I think, inviting, I'd be very surprised if any of the parties are inviting the court to say that the OFT has no power to enter into ERAs and to negotiate.
No, but it's quite useful if we are discussing ERAs just to know what the legal base is.
Well, I'm not aware, Mr. Beard will tell me if he is aware, I'm not aware of any specific power that is relevant here other than Section 25, which confers a power to investigate, Section 31, which sets out what the CMA must do when they propose to make a decision. They must give written notice and an opportunity to make representations. And Section 36, which gives them a power to impose penalties. And then Section 46 confers a right of appeal. Those are the relevant provisions. If there are others, my friend will inform your lordship.
Yes, to be clear, there is no specific power to enter into ERA settlements, nor, I believe, is there a specific power to institute the leniency regime. However, both of those are seen as incidents of the powers being executed in relation to the powers to make infringement decisions and to impose penalties. Whether or not this clip covers all of the relevant provisions, I don't think Lord Pannick is contending for at the moment.
No, if there are other statutory provisions that my friend thinks may be relevant, I'm very happy to show the court those tomorrow. But I respectfully agree. I've found nothing that expressly addresses the power to enter into an ERA, but I entirely accept it must be part of the powers of the OFT, now the CMA, to so act. My point is that it must be lawful for a body such as the OFT, as it was, to offer in its discretion to confer on a party the benefits of an ERA, and it must also be lawful for a body such as the OFT to offer to give a party such as TMR the benefit that was contained in the assurance. For example,
You're assuming that they were intending to give an assurance which would apply differentially to TMR.
No, I'm assuming that they are saying to TMR, we are going to confer upon you the benefit of a successful appeal brought by others. Now, the fact there's no legal right to such a benefit, in my submission, does not prevent the OFT from giving an assurance to TMR that it will enjoy such a benefit.
Well, there may be a difference here between saying to one of these parties, we are going to confer this benefit upon you, and saying to them, we think that this is a benefit that you've got.
Yeah.
And because the former gives rise to very obvious problems regarding equality, but the latter is a bit more unclear.
Well, the problem in this case is that Miss Branch simply didn't think about it, nor did...
Well, that seems to me to be more consistent with the second alternative than the first.
Well, with great respect, I don't accept that, because Miss Branch is not saying that on the basis of her understanding of the law, that's the position that she thought that TMR were entitled to.
What's absolutely clear from her statement is that she's not saying, I intended to give a special status to TMR.
Nor is she thinking that a policy decision need to be taken about whether we do or don't offer non-appellants the benefit of a successful appeal by somebody else. She just thinks she can just say what the, as it were, bog standard reaction of the OFT would be to that situation, without really having to take much further thought about it.
The difficulty I have, and respect the court has, is that her evidence simply states that she didn't think about it. And my position on behalf of Gallaher is it doesn't matter. And it doesn't matter because the long and short of it is that she did give an assurance to TMR which was not given to us. And as a matter of equal treatment and as a matter of fairness in the light of all the circumstances, we are entitled, I say, to the same treatment unless there is an objective justification for the difference. Now, my friend says the mistake provides an objective justification. But the difficulty, I say, with his argument, with my friend's argument, is that in 2012, the CMA decided, the OFT decided in 2012, to act on the assurance and to pay TMR a sum equivalent to the penalty that it had paid over, plus its costs, despite the principle of finality and legal certainty.
Well, what they decided was that having got themselves into a mess that they never intended to get into or realised they had got into, they were realised then that they were stuck.
Yes.
They were either going to be held to the agreement, if one can stop a public body, or else they were going to be faced with an appeal which would have been permitted, in which case they knew it was going to lose. So they were going to end up either way back in the position which applies now.
Yes.
And so it's difficult for you to rely on the payment to a TMR as anything significant because it was bound to happen one way or another.
Can't add anything to what
Yes.
happened originally.
First of all, the position they're in is as a result of them giving an assurance to one party but not to us. But secondly, the position they are in and the steps they took in 2012 cannot be answered by my friend's resort to the principles of finality and legal certainty. My point is that the solution that the OFT adopted in 2012 in relation to dealing with TMR could equally have been applied to Gallaher and Summerfield with no greater damage to legal certainty and finality than the approach that they took in relation to TMR.
Well, that begs the question whether Gallaher and Summerfield are entitled to be put in the same position as TMR. I mean, the one thing that's clear is that TMR had a pretty rock-solid position, which would one way or another entitle them to repayment. The whole question is whether Gallaher and Summerfield are in an equivalent position.
Yes.
But they can't claim to have been in an equivalent position by virtue of the factors which put TMR in so strong a position, namely the reliance and the express assurances.
I'm going to deal with that.
Yeah.
But there are 2 points in this case. My friend says that Gallaher cannot succeed in these proceedings because of an objective justification based on the principle of finality and legal certainty. That's one argument. The second argument is that Gallaher and Summerfield cannot succeed because they're not in the same position as TMR, or there's an objective justification because Gallaher and Summerfield did not rely on the assurance and TMR did. And those are two separate arguments. I'm dealing at the moment with the first of them. And the first argument is that we cannot succeed because of the principle of finality and legal certainty.
Well, it's because it would replicate a mistake based on ignoring the principle of finality and certainty, as I understand their case.
But my answer to that is that to treat us in the same way as TMR would involve no greater and no lesser infringement of the principle of finality and legal certainty than the way in which they treated TMR.
But you have to meet the proposition that maybe two wrongs don't make a right. Putting it loosely and shortly, but I think that is how one of my predecessors has put it.
but that isn't an argument based on finality and legal certainty. The way in which the OFT dealt with the matter in 2012 was to say we will not agree to TMR's insistence that the tobacco decision is revoked in relation to them, but we will pay back or pay over to TMR a sum equivalent to the sum that they paid by way of a penalty.
With some interest.
Plus
I think that
and some costs.
finality and legal certainty are really being relied on, aren't they, as reasons why the ERAs ought to be binding. That is the principle that is being applied as against your clients and which the authority would have liked to apply as against TMR if they hadn't cocked it up.
Well, they did cock it up. To use your lordship's expression. They gave an assurance to one party which they didn't give to another. And the justification, the objective justification that is being put forward, first of all, is finality and legal certainty. And I'm simply making the point that if it is consistent, sufficiently consistent with finality and legal certainty to pay over a sum of money to TMR, it would be no greater an infringement of finality and legal certainty to treat us in the same way. And can I show you?
But I wonder about that because there is the additional factor that in an ideal world, finality and certainty would apply to all, but TMR had the added card, which in this case may be the trump card of detrimental reliance.
And that's the second point which I'm coming to.
Yeah, but what I'm saying is you can't separate the first and second point.
But I do need to break down the elements of the argument.
Yes.
And my friend's argument is focused upon two limbs, one of which is finality and certainty, and the other of which is detrimental reliance.
Well, he did link them.
Yes.
Because he, I think, implicitly acknowledging that the question whether not replicating a mistake would be conspicuously unfair, one may legitimately look at the position not only of the original beneficiary of the mistake, but the possibly slightly different positions of the other people who would be beneficiaries of the mistake if it was replicated. And he made that part of his submissions on unfairness, not just on comparability.
He did.
I think because of a timing problem for comparability, which is 2008.
Taking it in stages, the first point, the first element of his argument is legal certainty and finality. We draw attention to the witness statement of the chairman of the CMA, Mr. Philip Collins, chairman of the OFT as he was at that stage, which is MS 277 to 278. This is the end of his witness statement. MS 277, paragraph 42. He says at paragraph 42 that in a letter, TM Retail set out its proposed terms of settlement, namely that it expected repayment of the full amount of its penalty, legal costs incurred since the tribunal's judgment, interest on the penalty, and the withdrawal or rescission of the decision as against it. It set out reasons for its demand for full payment, whereas the OFT had already indicated it was proposing to settle for less, and stated withdrawal of the infringement decision, which it admitted to, was of some importance for TM Retail, not only from a reputational point of view, but also because of the potential liability for third-party damages claims arising out of the decision. In relation to the question of withdrawal, that's withdrawal of the decision, the OFT's position had been that it would not withdraw or rescind the decision, either as to penalty or infringement, as this would be contrary to the principles of finality and legal certainty and defeat the very purpose of compromising TMR's threatened application to the tribunal. Following negotiations, TMR agreed to drop its demand for the rescission of the decision in return for the payment of the relevant sums. So the position of the OFT was very clear. Their position was that they did not think in 2012 that for them to pay over a sum of money but not to withdraw or rescind the decision was a breach of legal finality or certainty. That was their position. And all I'm saying, and I'll come to the question of detrimental reliance in a minute, all I'm saying is that the same could have been applied to us without, to any greater extent, damaging the principle of finality and legal certainty. And I submit to the court that the principle of finality and legal certainty is of no substantial importance in this case. It's of no substantial importance because we are not seeking any more than TMR was in 2012 in the agreement to overturn the decision. The decision will remain, as it does for TMR, that they were and we were in breach of competition law. The only question is whether there is any objective justification for the OFT reaching that agreement with TMR, but not being prepared to reach the same agreement in relation to us. And that turns on whether there is some distinction in the cases of TMR and Summerfield, and Gallaher and Summerfield.
But I mean, are you submitting that if a public body incurs a financial liability to a member of the public with whom it deals, it is bound to incur a similar financial responsibility in relation to any other member of the public in a comparable position with whom it's dealing? I mean, as you just pointed out to us, the authority did not in fact do what Miss what's her name? Branch thought it was appropriate to say that they would do. They did something different. Effectively, what they said is, we have got ourselves into a mess.
Yes.
We've incurred a liability to these people, so we haven't got any option but to satisfy that liability. We haven't incurred such a liability to people who are not in the same position because we didn't give them the mistaken assurance.
Yeah. And that's what this case comes down to, is the fact that they gave a mistaken assurance to TMR but not to us, is that a sufficient objective justification for their decision, the OFT, now the CMA, to pay back to TMR the penalty, but to refuse the same treatment to us in 2012, it not being suggested.
And it's not the same treatment. They are paying money to TMR because relations with TMR took a different turn to relations with you. They are not, you aren't asking to be put in the position that they were put in by Miss Branch's assurance, because that was an assurance that the decision would be withdrawn. That's not what you're asking for. What you're asking for is that the authority, having incurred a liability to A, B and C are entitled to be treated as if such a liability had been incurred to them as well. And that seems to be pushing the concept of equality quite a bit further than it's gone hitherto.
No, we are simply seeking equal treatment with another party to the ERAs who were given an assurance which, because that assurance was given to them but not to us, has led to the agreement in 2012, which is not in any way said to have been a mistaken agreement. It's a deliberate agreement by the OFT, which is based upon the assurance they gave to TMR in 2008. And we're simply asking for equal treatment. And we say it is unfair, grossly unfair, conspicuously unfair, however one wants to put it. It's unfair that TMR get this benefit and we don't when we were in the same position. And what is then said against us is, well, TMR relied and you, Gallaher, didn't. But that, with great respect, is a very bad point. And it's a very bad point because the only reason why TMR relied on the assurance in 2008 and we didn't is because the assurance was given to TMR in 2008 and it was not given to us as it should have been under the equal treatment obligation of the OFT and indeed under all the promises it had made.
Does that raise an interesting question as to what is meant by reliance?
If one were to use the expression detrimental reliance, then the answer might be different, because the point that's been made against you, as I understand it, is that you chose on legal advice to settle on the terms you did. TMR didn't before they had been given this assurance and could make out a respectable case that the terms on which they settled involved a reliance to their detriment on the assurance.
Well, but that's, with great respect, simply repeats the unequal treatment. They asked for a particular benefit which they were then given in terms of the assurance, and that benefit was not sought by us. But the whole point of equal treatment, the whole point of the policy that the OFT adopted in this context, the whole point of the repeated assurances, the consistency table, the emails to us, was that there would be equal treatment. And had the OFT complied with its own obligation of equal treatment in 2008, had it complied with its own policy, they would have told us of the assurance that they had given to TMR, and we would have been in the same position as TMR. But that didn't happen, and the only reason it didn't happen was because they breached their own obligations of equal treatment. And I say they can't rely as a justification in 2012 on their own failures to comply with equal treatment in 2008. That's what this case is all about. They have given a benefit on an important matter to one party out of 12 in 2008. They have failed to tell the others that they are doing so, contrary to their own policy, contrary to their assurances. And when it is said against them in 2012, you should give us now the same benefit, they say, but we didn't tell you of that assurance in 28, and therefore you didn't rely on it. Of course we didn't rely on it because we were denied knowledge of it at the time. What we did rely upon were the repeated assurances that equal treatment would be provided. If your lordships need evidence of that, it's in the witness statement of Isabel Taylor, page 250, MS 250. I've already read at 250, paragraph 12. She comes back to it at paragraph 16 at MS 251, where she says it was her understanding all the parties who'd entered into an ERA had been afforded the same treatment in the negotiation of their ERAs. No other parties have been given any assurances or commitments by the OFT that materially impacted on the terms of the ERAs. The OFT had made representations to that effect. I understood if there had been a change to the OFT's proposed treatment of one or more parties after Gallaher had signed the Gallaher ERA, Gallaher would have been notified of that change as occurred on the 8th of July 2008. And that was the email that I drew attention to. And Mr. Bingham's evidence, his evidence is at MS, starts at 241. He was the company secretary and director of Gallaher. He says at 242, paragraph 8, that all parties considering entry into an ERA would be treated equally. He returns to it at paragraph 13 at the top of 244, where he refers to the email. At paragraph 16, Gallaher relied on the OFT's statement it would pass on to Gallaher the benefit of developments in the early resolution process, the understanding there would be equal treatment of all those entering into ERAs. If Gallaher had contemplated the possibility of any party receiving an assurance outside the terms of the ERA, which it did not, Gallaher would therefore have assumed that if another party had been given an assurance about the effect of an appeal, the same assurances would have been extended to Gallaher. And then at 20, if Gallaher had become aware of the TMR assurances prior to the Gallaher ERA coming into effect, or indeed afterwards, I am certain, he says, that Gallaher would immediately have demanded equivalent assurances from the OFT on the basis that Gallaher was entitled to equal treatment with TMR, and indeed the OFT had plainly indicated that all parties entering into the ERAs would be treated equally. Gallaher therefore conducted its discussions with the OFT on the basis that all parties were being treated equally and a side assurance will not be available. Gallaher would have felt aggrieved that TMR had received assurances that had not been offered to Gallaher. So those are the circumstances. And in my submission, there is no requirement of law that in order to succeed in relation to a claim of unequal treatment or of substantive unfairness, that we must show that we, like TMR, relied on the assurance. I showed your lordships earlier this afternoon the statement of Lord Hoffman in the Banku case. It was in the judgment of Lord Dyson in Papinet, that it is not a requirement in the context of substantive legitimate expectations that there must be detrimental reliance. That is not the law. The question is whether or not in all the circumstances of the case there has been a lack of equal treatment or whether there's been substantive unfairness. Well, Lords, I've got a bit more to say, but that may be enough for today.
You've actually been allocated to us tomorrow morning, but it sounds as if you may not need it.
Well, I'm going to, I don't want to repeat myself, and I'm going to confine the rest of what I want to say, but
Yes,
Boyd is
of course.
going to follow me on behalf of some.
You've got to split it. I'm sorry, Miss Boyd.
She's going to make some points on behalf of
We're not hurrying you.
No, well, I'm grateful. I should have mentioned to your lordships. Your lordships, I think, know already that Miss Carstrisk is very apologetic.
Well, we understand the
problem
very
unfortunate over the weekend. Miss Boyd has
sorry.
stepped into the front row, and she is going to put some points for for Summerfield. I will have a bit more to say, but between us, we will undoubtedly finish by 12:30 at the latest to give my friend time for his reply.
Splendid.
Most grateful. My Lord, Lord Sumption asked for copies of the Tobacco 1 decision. Those have been secured. May I pass them up?
Give them to the architect.
I shall.
He'll give us them outside. Thank you very much indeed. We'll resume then at 10:30.